Right. In the interest of time, let's begin and then people can join in. Thank you very much, ladies and gentlemen. Good morning and good afternoon to everyone attending the webinar today. Welcome to this very highly anticipated webinar jointly hosted by HKSOA and international law firm Holman, Fenwick and Willan. My name is Captain Nitin Handa. I'm the Director of Regulatory Affairs with the HKSOA. Today we have the privilege of having with us Mr. Alessio Sbraga. He's a distinguished partner with HFW, and he has joined us to shed some light on the implications of the extension of EU emissions trading system, EU ETS, to the maritime sector and the application of the BIMCO ETSA clause for the time charter parties. Thank you very much, Alessio, for joining us today for this webinar. And we'll begin your presentation shortly, but just some house rules for the participants here. We'll be having a short question answer round after the presentation, so people can use the Q&A box at the bottom, put in their questions. We will take it up after the presentation. So without further ado, I invite Mr. Alessio to take the virtual stage. And Alessio, over to you.
Many thanks for the kind introduction, Nitin. Good day, everybody, and thank you also to the Hong Kong Ship Owners Association for inviting me to present to you today on what is very much a topic of conversation in shipping circles these days, and that is, as Nitin said, the EU emissions trading system. Well, I think I've lost count of the number of daily stories in the shipping press these days covering decarbonisation, and this only adds to the commercial uncertainty and debate in the market surrounding the key regulations which seek to regulate shipping's greenhouse gas emissions. And to be frank, it's all too easy to get drowned in all the noise surrounding this. However, the hope today is that we can try and cut through all this noise and give you a bit of clarity when it comes to the EU ETS. To this end, today's presentation will be split up into three parts. The first part, I intend to discuss the key features of the EU ETS and the main themes arising, including several key areas of uncertainty which still prevail. This should then provide us with the necessary context to discuss how parties to commercial shipping contracts, namely charterers, owners, and ship managers alike, might seek to navigate the EU ETS landscape, including managing liability and credit risk, as well as covering BIMCO's ETSA clause. I will then conclude by covering the potential disputes landscape, which could very well materialise when the EU ETS comes into force. And of course, if you have any questions, as Nitin said, I understand there's a Q&A facility, so please feel free to fill that up so that we can approach it after the event. On that note, let's kick things off. Well, I'm sure that most of you now are becoming very familiar with the EU ETS, given its extension to maritime transport. As we know, it's a mandatory cap and trade system that has been in existence since 2024 to various industries and to various participants. It works by capping the overall permitted greenhouse gas emissions of all participants in the system. Each participant must acquire emission allowances, described as EUAs, with each EUA being the right to emit 1 tonne of CO2. So in name and effect, it's not a tax. Emission allowances can be traded among the participants in the system and bought by those participants at live auctions on accredited EUA platforms such as EEX. However, the mechanics of introducing shipping into the EU ETS has been anything but straightforward over the past 2 years, with numerous versions of amendments made and produced by various EU bodies. But the good news is that the legislative text of the EU ETS directive, as amended, has now been formally published. So we have some certainty. Importantly, the MRV regulation has also been amended to operate alongside the EU ETS. And this really is key, as the emissions to be reported unverified under those rules will inform the quantity of EUAs to be surrendered on an annual basis by the relevant compliance entity. However, there is still some work to be done in terms of logistics for the EU ETS to work in practice for shipping. And that's a theme that I will come on to a bit later. In terms of how the EU ETS will work in practice, well, on a very basic level, the emissions of the relevant vessel each calendar year will be monitored in accordance with the EU's monitoring and reporting and verification regulation, as I mentioned, the MRV regulation. And the responsible compliance entity will be obliged to purchase EUAs from the market to cover their anticipated total emissions falling within the ETS. The responsible compliance party must then submit a formal a report for the vessel's emissions in the following year. And once this data has been verified, surrender the required number of EUAs to cover the vessel's emissions. However, there is an important feature to be aware of at the outset, and that is that responsibility for compliance here is company-centric. In other words, the focus is not merely on individual vessels or ship owners as such, but rather the focus is on the total aggregate EUAs corresponding to the emissions generated by the responsible compliance entity in a reporting period which need to be surrendered. In other words, this could be for multiple vessels across multiple ownership groups, depending on the identity of the responsible compliance entity, the shipping company. And this, again, is something I will come on to into more detail. In terms of key dates, though, well, the ETS will be extended to shipping from the 1st of January 2024. However, there will be a phase-in period from 2024 to 2027. So EUAs for only 40% of reported emissions will need to be surrendered for the 2024 annual reporting period, increasing to 70% of reporting emissions for 2025 and 100% for reported emissions from 2026 onwards. Now, even with this gradual introduction of emissions to be covered, the costs of complying with the ETS is likely to be a significant extra burden for the maritime sector to deal with. EUAs are currently trading between euros 80 and 90, and so the ETS costs relating to emissions for certain voyages could easily run into the tens of thousands or euros or more. Therefore, stakeholders will need to grapple with how these costs are managed, which is an important theme which we will discuss. Notably also, and this is important, the date for surrender of EUAs has also been changed from April to September of each calendar year, meaning that effectively September 2025 will be the first time EUAs will be surrendered. So some way off yet, but certainly not something which can be put to the bottom of the pile and forgotten. Turning to regulated emissions of vessels within the scope of the ETS, well, the EU ETS will initially apply to carbon dioxide emissions only from 2024. However, the methane and nitrous oxide will now need to be reported under the MRV regulation from 2024 onwards. And that also requires an updated monitoring plan to be submitted before 2024. But also, those greenhouse gases will be included under the ETS from 2026 onwards. This means that EUAs will need to be surrendered in 2027 in respect of carbon dioxide, methane, and nitrous oxides, therefore pushing up the costs of ETS compliance further in the years to come even more. And this, of course, will specifically impact LNG carriers, which emit methane through the boil-off process, and also dual-fueled LNG-powered vessels, which tend to be filling up the order books these days. So something for future-proofing going forward. The ETS will also apply to vessels over 5,000 gross tons only, and there are other exceptions for specialist vessels such as fishing vessels. However, Again, this may well change in due course because by the end of 2026, the European Commission will complete a study on the feasibility and impact of including vessels above 400 gross tons in the ETS, including offshore vessels above that size. In terms of regulated voyages, generally speaking, for voyages between ports of call within the EU and during an EU port of call, 100% of ships' regulated emissions will be captured under the ETS. For voyages between ports of call within the EU and outside the EU, then 50% of regulated emissions will be captured. Now, this approach obviously hangs on the term port of call, which you can see defined on your screen on the slide. Now, notably, this is defined under the ETS as a stop where a ship loads or unloads cargo, embarks or disembarks passengers, or in terms of offshore ships, relieves the crew. Consequently, other reasons for entering a port, for example, due to emergencies or solely for maintenance, crew changes, or even bunkering, will not break up the regulated voyage for the purpose of computing regulated emissions. So if we were to take an example, a voyage from East Coast USA to China via the Suez Canal, with a stop in Gibraltar for bunkering en route, well, that would not fall under the ETS unless loading or discharging at an EU port, a touch point with the EU, was also involved. Although there is a caveat to that on container transshipment ports, which we will now come on to. And indeed, there are other exceptions to the port of call definition, as you can see on the slide. Notably, this includes ship-to-ship transfers outside of ports, which are also included, meaning that these operations will again not mark the start or the end of a regulated voyage under the EU ETS. And the important takeaway here being the extent of total emissions of each of the vessels engaged in the STS operation will ultimately be determined by the location of those vessels' previous and next qualifying ports of call. Also accepted are stops of container ships in the neighbouring container transshipment point, as I mentioned. Now, to discourage the evasion of the scope of application of the EU ETS, the port of call definition also excludes stops by container ships in designated neighbouring container transshipment ports, which are ports within 300 nautical miles of the EU where they share around transshipment of containers in excess of 65%. Here, the European Commission will draw up a list of these ports by the end of 2023. And calls at such container transshipment ports will similarly not break up a regulated voyage. So emissions, again, will continue to count from the non-EU port of origin to the EU port of destination and vice versa, thereby catching as many emissions as possible. And of course, I think that it's probably important to mention that this actually represented a departure from the European Parliament's proposals, which had actually sought to apply this principle to all non-EU ports within a 300 nautical mile radius. So something to be aware of, because that could change in the future. Lastly, it should also be borne in mind that the scope of the ETS may well be expanded in due course to cover 100% of voyages to and from the EU. Should the IMO, for example, fail to adopt any global market-based emissions reduction measures, such as a carbon tax or a global ETS by 2028. In other words, the EU are throwing down the gauntlet to the IMO here in terms of further action or emissions. And to be perfectly frank, we can see that in the build-up to MEPC next week, where there is a concerted effort to push forward a more stringent net zero emissions strategy for the IMO. And then the EU delegation has already gone out there. But not wishing to digress, I think there are also, realistically speaking, two key points that ship owners, operators, and charterers alike should be concerning themselves with right now. And that is twofold. One, responsibility for compliance, and 2, responsibility for the EU ETS costs liability. As for the key issue of responsibility for compliance, well, this squarely rests with the shipping company, which is defined under Article 3W, which you can see on the slide. And it should be noted the same definition has now been included in the amended MRV regulation. Here, a shipping company could either be the ship owner, technical manager, or bareboat charterer, where either of the last 2 entities have assumed responsibility for the ISM document of compliance under the ISM code. However, what this means is that the plain and ordinary language used in the EU legislative text does not clearly identify who the regulated compliance entity is. Indeed, it could be either the ship owner or what I will describe now as the ISM dock holder, if of course that is a different entity from the ship owner. Instead, the legislative text effectively leaves it to the EU Commission to decide, by way of an implementing act, which entity goes on the list of shipping companies before the 1st of February 2024, thereby leaving an uncertain landscape as matters stand. And this really is a very relevant consideration for 3 principal reasons. First, principally because a uniform approach should be adopted between member states as to which type of entity goes on the shipping company list. Secondly, because the identity of the shipping company will also determine the identity of the administering authority. In other words, the member state entity responsible for regulating the compliance of the shipping company. Thirdly, because it is the administering authority who is required to invite the shipping company to open a registry holding compliance account in that member state. So what that means is if you are a shipping company based in the EU, this shouldn't be so much of a problem. However, for a non-EU shipping company, this will depend on the most number of EU ports of call made to that state in the last 4 years. And remember, this involves all the vessels under the shipping company's fleet, depending on the identity of that shipping company. So potentially not straightforward. And specifically from a technical ship manager's perspective, if that entity is to go on the EU Commission's list, then this will also be very important because, of course, a technical ship manager's portfolio fleet could look very different from that of a ship owner's fleet, especially if that ship manager is carrying out a ship management function for different ship owners. And this will have a direct impact on the identity of the administering authority. But also because the implications of compliance are likely to be more cumbersome than that which the parties, that is the technical ship manager and the ship owner, envisaged when they entered into any ship management agreement, for example. Again, a theme which I will revisit in a bit. So all this just goes to serve to highlight that the important role that the EU Commission actually has now to play in terms of formally deciding which shipping company goes on the list and how this will work in practice through implementing acts. But there is arguably another reason why the identity of the shipping company will be a very important factor going forward. And this is because it is the only entity who can enforce any right to reimbursement for EU ETS cost liability. Indeed, the EU ETS legislative text expressly provides where a third party has assumed responsibility for purchasing the fuel or the operation of the vessel under an underlying physical transport contract, that third party will be liable to reimburse the shipping company for its EU ETS costs. And member states shall make necessary arrangements under their national law to enable the shipping company to recover these costs by way of statutory entitlement under the member state national law. So in other words, depending on the nature of the underlying physical transport contract, the EU ETS cost liability will be transferred from the compliance entity to the third party. And this applies irrespective of whether there is a specific EU ETS provision, for example, under the contract. But the right to take and enforce any such liability against that third party rests and vests in the shipping company. Now here, as you can see on the screen, the operation of the ship is defined as the entity who has the ability to determine the cargo carried or the route and speed of the ship at Article 3GC. And drawing all this all together, whilst the wordings could still, again, have been much clearer, the position is that the EU ETS costs will be for a time charters account under a time charter, and potentially could also be for a voyage charterers account or COA counterparties account, depending on the terms of that underlying physical contract. For example, under the definition of operation of the ship, this could catch wet charters where, for example, speed and routing have been warranted by the owner to a charterer, or where, for example, charterers have been given an unfettered right to determine the cargo. And to achieve this transfer of liability, the recitals of the legislative text make clear that the statutory entitlement under national law to claim reimbursement of the EU ETS costs from that third party responsible should apply irrespective of any choice of law clause in any underlying contract at recital 20, which may be used to try and circumvent such entitlement in an EU member state. So obviously, a clear intention here is to try and pass on the costs of liability for the cost where it has not been possible to negotiate this under an underlying contract. A very new and unique way of doing it, I would say. But how and whether this will work in practice remains to be seen. Against this background, though, there are also two key areas that a lot of clients are currently focusing on, and that is the practical process of setting up union registry accounts for holding and transferring EUAs, in other words, the compliance account, and the potential financial regulatory implications of dealing with EUAs. Now, in terms of registry accounts, there is a basic distinction between operator holding accounts and trading accounts to be aware of. An operator holding account can be opened by a responsible compliance entity, in other words here, the shipping company, and it is the account from which it will surrender the EUAs to its administering authority by the 30th of September each year to meet its compliance obligations. Trading accounts, on the other hand, as the name suggests, are for trading of EUAs only, and they can be opened by companies or natural persons that are not compliance entities. So, for example, charterers. The current issue with operator holding accounts is that these cannot be opened until the EU Commission publishes the list of shipping companies, something I raised earlier, and that will not happen potentially until 1st of February 2024. Consequently, we have seen many parties looking into opening trading accounts so that they can enter into the market now and plan ahead. However, the relevant formalities involved in setting up any type of account will depend on the type of entity involved, the type of commercial activities of that entity involved, and local law advice from relevant member states involved will almost certainly need to be obtained to ensure everything is done in accordance with those local laws. And that's because dealing with EUAs or trading in EUAs could also give rise to issues under MiFID II or the European Market Infrastructure Regulation. Because at the end of the day, an EUA is a financial instrument. And we have had several requests from clients recently to advise on whether these activities fall under the available exceptions under those regulations. And there's no one rule fits all. So that's something also to bear in mind. But regardless of these issues, I think one thing that we can't lose focus on and sight on really is that the overriding responsibility for compliance, notwithstanding the transfer of EU ETS cost liability, rests and remains with the shipping company at all times. And that means that the shipping company remains responsible in the first event for any failure to render EUAs on time, which will be met with a fiscal penalty of €100 per tonne of excess CO2, plus any short EU. And shaming compliant shipping companies will also be made. And non-compliance for 2 years, 2 consecutive years, may result in refusal of entry into EUA ports to any vessels belonging to a fleet of a shipping company. Something, for example, which could be very worrying for a technical manager is the shipping company. And last but not least, there continue to be no free allocation of EUAs for shipping, and there will be no specific allocation of EUAs to shipping. So what this means is that, again, the ability of EUAs is only likely to go up in these. But regardless of whether liability for EU ETS has been transferred under the legislative text, the reality is that allocating risk and responsibility under contracts still has to be the preferred option for the parties here, because it would provide and ensure both parties get what they want out of the EU ETS regime. Starting with potential contract charters, provides a relatively no-nonsense commercial standard. That's even wider than the EU ETS. And I would submit that it will achieve what has now been in the EU ETS legislation. Slide I thought to highlight some of the key provisions, those being that the ETSA clause really works on the principle of transferring allowances as opposed to reimbursing for the cost of allowances. In terms, it states that charterers will transfer allowances to owners each month on calculations carried out by the owners under sub emission allowances themselves, the currency of exchange between the parties, it questions over the timing and price point of emission allowances being purchased on the ever fluctuating market, potentially by owners or potentially even by ship managers as the responsible party for compliance, if that's the arrangement, or the determination by the EU, could lead to significant costs outside of their control. However, off-hire periods are excluded under Clause C, and emissions generated during these periods, which require emission allowances to be surrendered, will need to be. So it's not a question making it the responsibility of charterers. There remains and will remain residual responsibility for the owners. There's also mention under subclause D, should charterers be in breach of their obligation to transfer allowances. And the clause, as I mentioned, also has potential wider impact ETS, given that in reality, in the years to come, if you have a long-term time charter that you're entering into, the reality is that other emissions trading systems are likely to evolve and become relevant. China, US, Japan being can stand. With many industry standard clauses, this clause is only a starting point. And we all know that parties are considerations going into contractual negotiations, the type of the vessel involved, the length of the contract, seeing negotiating contractual solutions around the in a time charter context. These are different to the EU ETS on both sides, which often depends on business strategies. But in terms of relevant considerations and practical tips contracts, I think the starting point always has to be that under a time charter, the position is very clear. It has to be in charterers' interest to stay in control and earmark their risk and responsibility on terms which they agree to be in a clause to be inserted into a contract, and not risk being faced with a potential recourse action in a local state court, potentially which may of the shipping company. This is especially when the uncertainty by the EU legislative text itself. Describe it as the things that the text. So, for example, of costs, and it could be why a cost and include any costs arising out of the surrender of allowances by the shipping, any penalty to surrender, something that's recital 32 hints at. Also, the EU legislation, of course, does not take account of commercial considerations. So no provisions or carve out obvious exceptions to the obligation to meet the ETS costs where, for example, emissions have been expended for owner's account only by way of a breach of contract. And on the flip side, for a ship owner, relying on the statute to reimbursement depend how the state interprets the EU ETS directive as transposed into, and we could very well see 27 different results achieved at the end of state of those states. So our clear here to agreeing an appropriate clause, and I would go as far as saying even more so. And as for the content of any clause and the considerations, I think it would be prudent for a charter scope of the emissions trading regimes to be covered, even the type of GHG emissions, although they have exerted in a long-term charter which involved a dual fuel engine, for example. Agreeing for transferring EUAs which activities against counterparty or credit risk may also be a sensible consideration. For example, especially where the surrender obligation for the previous calendar year does not take place much later in time. For example, calendar year 4 is the first date of surrender. Although, of course, in a long-term charter and prior to a reconciliation provision at the end calendar reported period, that is, for example, catching any provisions may also represent a reasonable compromise for both parties. There may also be a role for an independent third-party verifier, especially in time charter, or where, for example, redelivery happens, client's report kicks in. So what the certified verified emissions should be. Alternatively, a different mechanism, cost liability, may be appropriate. For example, other than EUA, and it could vary either short-term period time charter, and whether on a time charter basis and voyage chartered out on a spot basis. So it may be very deep, the concept of transferring EUAs back to back into a voyage charter scenario. Ways to ring fence liability and exposure, in particular for a ship owner, I think just like any counterparty risk, for example, non-payment of hire, there are always ways providing for termination or an annuality, or even exclusion of trading areas or EU non-surrender of emission. Some kind of parent company guarantee may also be appropriate to provide some kind of comfort. And as for responsibilities for penalties and fines, well, an indemnity provision may also be appropriate in addition to a breach of contract call. It really does depend on the nature of the bargaining power here. But as I mentioned before, ability of part of this chain is not simply a time. So for days, cost should be built into itself or represented as a certain cost. However, the difficulty here would be agreeing on or benchmark for determining the EUA equivalent cost, difficulty on the scope of emissions covered by any voyage. For example, whether it should be limited to discharging actions or also include any appropriate ballast voyage. And of course, how and when any funds should be exchanged may also be a sticking point between the parties. Ultimately, I doubt there will be one common position here, as it will largely depend on the underlying physical contract. Remember, not all of the voyage charters may be caught by the plain and ordinary language of the EU legislative text, but ultimately on how the national law interprets that statutory right of reimbursement. And so I suspect that we're probably more to see shipping companies trying to pursue their statutory entitlement in a member state in a voyage charter context where specific clauses have not been agreed. And as for bareboat charterers, well, the party's primary responsibility under the ETS, as they are often named the ISM dock holder, oversight and proof of compliance, which impacts their asset, may need to be protected upon redelivery. There are also implications for pool agreements and sale contracts to consider, and which we have actually advised on. But the reality is that's outside of the scope of today's presentation, if we're going to keep to the time schedule. But paying now particular attention to ship management contracts, and given that it is in a technical matter, as ISM dock holders could end up being on the responsible as per the list, means that the nature of compliance, the likely sums involved, and the nature and terms of the underlying physical entered into by ship managers are all key considerations when reviewing existing and future ship management contracts going forward. And in particular, if the ship manager is performing a commercial role under, for example, Shipman 2009. Now, as the shipping company, compliance obligations will range from being responsible for monitoring and reporting on the regulated emissions for each ship under responsibility in accordance with the MRV regulation, the setting up of a registered account and perhaps trading accounts in more than one jurisdiction, and surrendering the requisite amount of verified emission allowances, EUAs, to the authorities on time and on an annual basis. Now, for the first obligation that you can see on the slide, this may already be familiar to ship managers if they have been carrying out that function to date in accordance with the MRV. However, important to note is that the amended MRV regulation and increased scrutiny of emissions reporting will certainly up the ante and involve heightened attention and vigilance going forward. Whereas the second and third obligations you can see on the slide will not be familiar at all. Quite simply, the second obligation may involve extra expense and manpower. However, a registry account would almost certainly be a different account in nature from the account provided for clauses, for example, clauses 11A and B of Shipman 2009. And it would probably be difficult to deduct any expenses in that regard either. Aside from that, clause 12C may operate to cover extra expenses incurred in setting up and operating a registered account, but that wording would probably still doesn't go far enough, in the sense that it probably normally envisages out-of-pocket expenses if it is unamended and not expanded in scope. Failure to comply with the third obligation will, as explained a short time ago, result in a fiscal penalty being imposed against the shipping company, which would involve €100 per tonne of CO2 equivalent, plus making up the shortfall of the emission allowances. And with the costs of EUAs going up over time, that is likely to be a significant financial exposure for ship managers. And yes, the wide exception and cap at clause 17B and the indemnity provision at 17C of Shipman 2009 could operate to insulate ship managers from any fiscal penalties in the event that insufficient funds have been received from ship owners or whoever in the underlying physical transport contract has been allocated responsibility for the EUA costs. But it's important to bear in mind that there is no mechanism under the existing Shipman pro formula to facilitate compliance. Indeed, quite often, the underlying physical transport contract will determine what technical managers need to do in order to comply. So, for example, payments or the surrender of EUAs from charterers, or whether technical managers' mandate is to purchase the EUAs on behalf of a particular vessel. There's also no apparent protection for ship managers where there is a change of ownership of vessels managed, or for example, an insolvency situation where an indemnity would be of relatively little value, leaving ship managers in the worst case scenario with a potential significant commercial exposure. This, of course, could be made worse where there are multiple defaults from ship owners impacting the ship manager who would be reporting for all vessels in its fleet. Again, that point that I made at the beginning of the presentation, the shipping company centric point. Now, to deal with this, we'll probably require tailor-made provisions which seek to earmark these exposures. However, thought will need to be given to whether technical managers are willing to offer this service in the first place. If, for example, they have ticked the box that they are a company and that therefore go on the list that has been produced by the EU Commission. But importantly also, how technical managers, ship managers intend to carry out this service for ship owners and on what basis and at what cost. Although it may be very difficult to build this in as an upfront cost in the budget or even as a running cost in the management fee, given the fluctuating price of EUAs. It would also require a mechanism to insulate and protect technical managers from the above risks if they are left carrying the can for the EUAs as the responsible shipping company. Now, having said all that, I understand that a specific BIMCO Shipman EU ETS clause is currently being developed as part of an overall revision of Shipman. So important and interesting to see how these issues are eventually covered off, and I suspect they will be. So there's clearly a lot to consider when seeking to cover off the EU ETS in contracts, but there also seems to be a lot of scope, unfortunately, for potential disputes, and that applies to whether you have or you do not have bespoke contractual provisions covering the ETS. For example, even when clauses are agreed, there could unfortunately still be disputes. For example, over the amount of EUAs requested from charterers by owners and how that amount has been calculated by those owners. In particular, how the emissions have been calculated under the amended MRV regulation, particularly before they have been verified by the accredited verifier of the vessel. And this will be especially acute in short-term contracts which conclude prior to official verification, and also in the redelivery scenario. Of course, disputes where charterers fail to either provide or pay for the allowances requested, for example, perhaps where there is a disputed off-hire in a time charter context. And of course, the potential involvement of member states here in terms of enforcing the reimbursement of costs adds another layer of complexity and uncertainty, as does the dynamics of any contractual charter chain involved. And of course, this is just what we can envisage now, and there could be numerous other forms of dispute which could arise in due course. So putting this all into context, that leaves us with what I consider to be a very, very important question. And that is really, what should the main stakeholders in the physical transport chain be looking out for going forward? And realistically speaking, it's not an easy question to answer. But in terms of what we know right now, whilst the EU ETS appears to be relatively certain in terms of what types of emissions will be regulated and when, the EU ETS framework, the logistics, still needs clarity, and vigilance is certainly required by the parties going forward. Formal determination of the regulated entity as the shipping company will be important because, as we discussed, it's linked to the setting up of registry holding compliance accounts and in which member state, and determining the role and involvement of a technical ship manager in the EU ETS compliance regime. The inclusion of methane and nitrous oxide as regulated emissions from 2026, but the obligation to report from 2024 under the MRV regulation, obviously with methane slip in mind for LNG carriers, will be an important point to bear in mind going forward. The real potential for other greenhouse gas emissions to be included in the EU ETS has to be borne in mind. And there are also inbuilt EU review mechanisms in the EU ETS directive itself in terms of monitoring of evasive behavior on a continuous basis and the tightening of the EU ETS. So, for example, where it's determined that parties are seeking to make shorter port calls to ports outside of the EU prior to making calls at the EU, similar to what we've seen to the container transshipment port list that's being produced by the EU. And of course, in the absence of a global market-based measure adopted by the IMO to regulate shipping's emissions, outbound voyages attracting 50% of emissions could well be increased to 100% come 2028. And whilst outside of the scope of today's presentation, but still important, is the role that each party has to play in this. Each party has to decide what risk profile they have to EUAs and whether this includes trading in EUAs. In particular, whether the EU ETS should be considered more as a compliance liability issue, so for example, burden, or as a risk management issue, where it can be used as an opportunity to generate revenue, especially given the fluctuating prices of EUAs. And last but not least, ensuring that a party's liability for EU ETS costs is ring-fenced in contracts, and that will be paramount. And this is because it's not really advisable for a ship owner to rely on pursuing any statutory entitlement under the legislation in a member state, as this is only likely to be complicated, time-consuming, and costly, and likely to result in satellite litigation. And just to provide you with some perspective on next steps in the amended MRV and the EU ETS, you will see on the screen a timeline which may be of use, and it draws from the many points that we have covered today. I appreciate that it's quite a lot. And on that note, really, I open up the floor for any questions that may have been received on the Q&A. Many thanks.
Thank you very much, Alessio, for very clearly highlighting the complexities of the issue and kind of providing that there's no one solution fits all kind of a provision here. We do have some questions listed up. I'll take them up, and meanwhile, I'll ask the participants to type in any other questions if they may have. The first question here, Alessio, is how will the administrating authority enforce the reimbursement of EUAs if the charter is not based in EU?
Thanks, Nitin. I think that's a very good but very difficult question to answer. I think in the first event, it will depend on the nature of the member state. It would depend on the national law that's being applied. And in effect, really, how that national law interprets the reimbursement itself. We covered the perspective of time charters and voyage charters. Under a time charter, it'd be relatively straightforward to identify the party for reimbursement. But the quantity of those costs could very well be in question. How to enforce it? Well, that's a very good question, really, because you would presumably have to obtain a judgment against that entity, that third-party entity that's responsible, and then seek to enforce it in the normal way that you would have a normal judgment. Of course, the slight wrinkle here is that you will have individual contracts which provide for, as freedom of contract does, law and jurisdiction, which may provide for a different jurisdiction. And you could potentially have satellite litigation, anti-suit injunctions, especially here in the UK, obviously English law being a relatively known commodity in terms of provisions in contracts. But then again, another wrinkle is that essentially it depends on who is enforcing that right to reimbursement. If I give an example, if the EU determines that it is a ship manager who is a shipping company that is to go on the list, then the reality is, and you have a time charter which is entered into by an owner and a charterer, in theory, you would have a shipping company being the ship manager seeking to enforce the rights to get the owner reimbursed, presumably under a shipman contract. Of course, if then a charterer wished to try and avoid that, the difficulty potentially that charterer would have would be, well, the right that he would have under the contract would be against the owner, not against the ship manager. And therefore, you would not have privity of contract to say to the ship manager that you are not entitled or in breach of an exclusive law and jurisdiction clause. I'm not saying that's a complete answer, but those are the kind of problems you're likely to face.
Yes, and like you mentioned in your last slide, ring fencing around all the contracts between the charterers and the owners and the ship managers would be the key to kind of resolving these sort of disputes.
Exactly.
Yeah. I'll move on to the next question where it says, if a ship manager and ship owner decide that a liability for surrendering EU ETS rests with the ship owner, can this be communicated to the EU Commission, and if so, by then? If so, this is something at all possible where ship owner and manager can choose who would be the listed as a shipping company in a certain scenario.
I think I can't answer that question at the moment, but what I can say is that there is lobbying and discussions going on, I understand, between the various appointed shipping groups and the EU Commission, seeking to get clarity on what can and can't happen in terms of the responsible compliance entity. And there are several options on the table in order to do that, not only talking about which individual party will go on that list, but also the sort of logistics around it. Because of course it is a very important question to be answered. And it's one which, to be perfectly frank, the legislation should have provided for with certainty. But I think from the Commission's perspective, they probably simply want to ensure that there is a compliance entity. And in some cases, that compliance entity may be better to have as the ship manager. In other instances, it may be better to have the ship owner. Of course, if you have compliance entities that are shell companies on a list, they're not as it's not as easy to enforce penalties against them as it would be for other entities with substance. So yes, that I can't answer that completely, but hopefully that helps.
I suppose we'll have to wait for the enforcing act or the secondary act to come out, and then things will be a little more clearer about the enforcement.
Yes, I mean, I'm hoping that at least the identification of which party goes on the list and the information around that will become known towards the end of this year, Q4 this year, in anticipation of the deadline of 1st of February 2024. but it really depends on how those discussions go and the decision that's made by the Commission in the implementing act.
All right. Yeah, so we move on to the next question. Will the document of compliance reflect whether the EUAs in respect of a particular ship's emission have been surrendered? So essentially, is it going to be reflective of each ship's emissions, or is it going to be for each company's fleets or the listed company's fleet emissions as a whole, per se?
I think what's envisaged by the MRV regulation is that you get a tick for both vessel verified emissions signed off by the administering authority and the flag state, and also the company's aggregate vessel emissions as certified and verified. So you effectively get both, because at the end of the day, the liability attaches to the company as opposed to the vessel.
Correct. And I suppose if that would also come in handy in case of if there is a vessel which is handed over or moves out of a certain technical management's fleet and goes into another manager, or a ship is sold to another owner, then they would be required to verify whether the ship is already in compliance or not with the submissions of the allowances.
Yes.
All right. We'll wait. We are still waiting for more questions to pop up. In the meantime, maybe I can take up some other question about the difference between the trading account and the submission account or the operating account. You did touch upon it a little bit briefly, but if you could elaborate a little bit more, as in, will a ship manager or a ship owner be allowed to open a trading account as well, or is it just that they are required to open the submitting account, and all the charterers will be opening the trading accounts and submitting it into their this thing? And also, if they go ahead and buy it from the market, buy the EUAs from the market, will that directly be allowed to put it into their submitting account, or do they really need a trading account for it to come in?
Good questions, Nitin. I think so. Dissecting that, I think the first point to note is that only participants in the market, so compliance entities, can enter into live auctions. So that's the primary market of obtaining the EUAs. Then there is the secondary market, which is the traded market, which all those participants and other entrants into the market can purchase those EUAs. If a ship owner or a ship manager would want to obtain or open a trading account, that is possible, subject to going through the relative KYC criteria and national law criteria, and basically forum shopping, deciding where and which jurisdiction best suits them in terms of their business and their operations to open it up. It's not as easy as one may think. There's lots involved. At the end of the day, again, it's a financial instrument, so there are other issues to be considered, such as MiFID II, as I mentioned. But that entering into the market and dealing with financial instruments is an opening of trading accounts is probably more of interest also to charterers entering into the market, who, if they don't have who don't own vessels themselves and are not listed as a shipping company and not a compliance entity, therefore they have to look very carefully as to whether they are entitled to enter into the market and what their activities are, and whether they can make use of exceptions to MiFID II. And that's a complex question to answer. But yes, ship owners and ship managers in theory can do that and enter into the market, open a trading account, especially as the compliance accounts aren't ready yet, but that would require due diligence and local law advice. And in terms of transferring, meeting and surrendering EUAs to meet the compliance obligation, the simple answer is that it has to be surrendered via the compliance account. So you could have a trading account, but the trading account would have to feed into the compliance holding account.
Right, right. I have a couple more questions here. What are the implications for a financial leasing company with their bareboat charterers as financiers opposed to a true owner?
It's a very good question.
I would suppose it
yeah.
would be something related to the contract they have with the actual ship owner, possibly.
Yeah, I mean, it ultimately, there are two key considerations. One, whether you fit the bill for a compliance entity. It depends on who goes on the list effectively by the commission. So so for example, what I'm saying is that the individual contract wouldn't change that. That would still be the case. What you would do under the individual leasing contract is you may allocate risk and responsibility for that differently to get a different solution. But there would be implications involved there depending on that underlying contract, who is described as a technical manager, what responsibilities they actually do have. So if there is assumption of responsibility that fits the criteria under the EU legislative text that makes them a shipping company, then of course, assuming there may be an assumption of responsibility towards the EU that otherwise wouldn't have been there had this legislation not come into force. Right. So two issues. What does the EU provide for and what does your contract provide for?
Right. Moving on, in terms of account opening, the documents required include VAT certificate. What happens if the if the company is incorporated in a jurisdiction where VAT registrations is not relevant? Example, Hong Kong or BVI.
I think that would be difficult for me to answer. And I think that would be a very relevant question, mind you, but it would depend on the individual member state which you are seeking to open up the trading account, or the compliance account as well. So it applies to both. And they have their own KYC criteria. It depends on whether you have a branch based there as well. Their documents of compliance may be more stringent in certain jurisdictions than others. And of course, that's why you get into the question of forum shopping, really, as to where suits you best.
Right. And I suppose it's a commonly known fact that the companies outside of EU do not have a VAT. So it's generally accepted that they would not ask for a VAT certificate unless there's some kind of a tax agreement between the two jurisdictions, I suppose.
Potentially.
Right. The next question is, account opening requires member state bank account. Is this compulsory for a non-EU company?
Again, a difficult question for me to answer, although a presence in that country is required, and I assume that it goes with it that probably a bank account is needed for KYC verification purposes as well, and also to confirm that purchases can be made from a money laundering perspective, most probably also. Right. But it depends on each individual member state's perspective, right, which I can't advise on, unfortunately.
How will a ship's emissions be verified? Will the EU set up somebody to do this? A certain body will be set up for verification, or is it going to be through the amendment to the MRV regulations?
It's purely on the MRV regulations. There are 11 approved verifiers at the moment that are accredited, and it would be up to the individual vessel or the shipping company that's in charge of those vessels to identify the appropriate accredited verifier to that, and that will then feed in to the compliance regime that's required under the MRV, both for the vessel and the company's aggregate total emissions.
Right. This is a build on from the previous questions about the bareboat charters for financial lessors. Can innocent owners' interest insurance be a way to mitigate such risk?
I'm sure there's going to be some very interesting insurance products out there in due course. That may well be possible. From a sort of a P&I perspective, I don't think they offer it, but I'm sure there are going to be various insurance products out there to cover risks and liabilities going forward, what the costs of that would be, and the criteria would be to meet it. I don't know, but given that the cost of EUAs and the implication of the price likely to go up in terms of the market being driven by lack of allowances, the move towards using less fossil fuels, trading, the cost is only going to go up, and where there's costs, quite often insurance follows.
Right. While we wait for some more questions, I have one question for you here. What happens if a ship is chartered to another shipping company with a listed entity, I would say? Say, for example, a ship owner is chartering out to another company, which is chartering as well as being a ship owner. So what happens then in that scenario? Do the DOC holders still remain the party to liable to submit the allowances, or can that be transferred to the other listed company?
It depends on whether it is determined that the ship owner or the ISM dock holder is the appropriate responsible compliance entity. So it almost at present on the legislative text as it stands, the physical contract doesn't really enter into it, save for where it passes on responsibility as an ISM dock holder. So you could have a ship owner that remains the ISM dock holder, in which case it'd be relatively straightforward who goes on that list. If you have a ship owner that then allows someone else to assume responsibility for the ISM dock holder, then it's a question of those two entities. But it depends. It depends on which party goes on the list. I suppose you would say to me, Nitin, but you've got two kinds of ship owners here.
No,
Actually,
I'm
by nature.
I'm actually adding a third entity in this, where a charterer who is also a ship owner charters a ship out from another ship owner, and then is only for, say, a voyage, not as under the
Right.
management, just for the voyage. And can the charterer then say that, okay, I have got sufficient EUAs in my account, you don't worry about this, within their voyage charter contract, and say that, okay, I'll take care of it?
I think that charterer could do that, but in terms of compliance, they would only ever be a disponent owner, so they wouldn't be the ship owner as per se.
Yeah.
But yeah, a charterer could do that, and if he had time chartered it out, in theory, that time charter would be responsible for the EU ETS costs anyway, so it would be their cost liability. And yes, they could do that. The question would be then if they try and pass that cost liability down, if they can.
Yeah, so in such a scenario, can a charterer who's holding EUAs pay the owner by transferring the EUAs rather than paying them a monetary value?
Yep, it depends on the parties can decide how they regulate the cost liability between them. Of course, the charterers can't satisfy the surrender obligation. They would still have to transfer it to the compliance account,
Right.
but it could equally be cash. And I think that what I find is that those parties that are already familiar with EUAs, trading, commodities houses, charterers, big charterers, that they are already familiar with EUAs. And the reality is that they would probably prefer to, I wouldn't speak for all of them, but they may prefer to transfer liability in terms of allowances rather than cash. But it really depends on what the business structure is and what the end point of the physical transport chain is, because you could easily have a situation where you've got it on time charter and voyage charter, and under the voyage charter you get cash, but under the time charter you pay EUAs. So how do you deal with that as a business?
Right. Right. So again, we come back to the same ring fencing within all the contracts issue. Right. I don't have any more questions, but I'll ask you one of mine. This ETS is essentially a cap and trade kind of a system where a lot of revenue is expected to be generated for the EU. What is, if any, plan for where this revenue is going to go?
Well, there is a certain monetary fund that's earmarked for green transition development, which funds will go into. So that will be a very important element of where the costs go to, although that's not all the costs. My understanding is revenue from EUAs. But probably the other important point really is the other side of the coin to this, which is really Fuel EU Maritime. This is only part of the story in the sense that it's an existing system that's applied since 2005 and works. And it works by, as you say, cap and trading use of fossil fuels. And it's only going to become more expensive going forward. But to actually forcefully make that transition from fossil fuels to more low carbon e-fuels, net zero emission fuels, you need another measure. And that is really the Fuel EU Maritime. And that's where I think is going to be the most important change for the parties going forward. This is relatively tangible. I think with the Fuel EU Maritime, with the greenhouse gas intensity indicator and various rewards that can be given to e-fuels, such as biomethanol, bioammonia, those types. I think that's the real transition. I think that's where the real influence is going to be going forward.
So essentially, there's no sort of a reward for first movers apart from lesser purchase of EUAs based on their reduced emissions, isn't it?
Well, there do exist contracts for difference, but they apply slightly differently here. But there are rewards for clear or rewards for first movers in Fuel EU Maritime.
Right. And as you mentioned, MEPC 80 is next week, and there is a discussion on more market-based measures and long-term measures which are going to be taken up. So assuming there is some sort of an agreement reached and a levy-based sort of a system similar to the cap and trade is introduced, how soon or how early do you see EU actually taking an action of reverting this ETS, and if at all, is it possible that they would?
Well, there is a review mechanism set up in the EU ETS by 2028. So that's the deadline set for IMO, and that's the deadline when they could review. My personal view is that even if a global cap and trade system or carbon levy is introduced, this will still continue, simply because I think the EU are very clear in what their strategy is. Their strategy is to become the first net zero emissions continent. And shipping really is just one part of a big jigsaw puzzle where they are seeking to decarbonize the whole of the economy. So having special dispensation for maritime may not fit the criteria and certain criteria for achieving that net zero ambition.
Right. So assume it's here to stay for at least another 5 years.
I think so. I think the interesting point potentially going forward is if you've got a trade that involves lots of calls to the EU, where the EU ETS liability is quite high, and you have a time charter contract, will there be more of an incentive to go slower in order to reduce the EUA cost liability? And if that's the case, will it encourage more collaboration and better performance for CII, for example, under the MARPOL carbon intensity regulations? That's an interesting point, because of course the big sticking point in CII is always, well, business as usual, and the complexities involved in trying to achieve CII compliance is very, very complicated. But this may be one aspect that can assist with that ultimately. But you probably wouldn't get there until 2026, when you've got 100% of emissions counting towards the EU ETS.
Right. And there is a CII review also going to be taking place in 2026, I suppose. So we'll have to wait and watch. Right.
Yes.
I have a couple more questions here. Is it correct to say every ship owner has to set up a registry account and a trading account with EU? And if so, which EU member state?
I would say no. I would say the obligation is only to set up a compliance holding account, operators holding account, and that would depend on who the compliance entity is. So it may not be the ship owner. And secondly, it's possible to have a trading account depending on the business strategy and whether you meet the criteria of a member state. As to which member state, it would really depend.
Right. And there's another question here. Does the ETS report to be verified by any certified organization? If affirmative, how to know the list of certified organizations which will certify the ETS reports?
Good question. It's the accredited verifiers approved by the EU will verify the emissions. And I believe that there are 11 of them. And I believe that BIMCO have a link to the current 11 regulated certifiers, exactly. Now, the interesting thing would be whether that list increases in due course. But along the list of those verifiers are also classification societies as well. So it's a strong 11 list.
Right. No more questions coming in right now, and we are about time as well. So I think we'll call it off then. Thank you so much, Alessio. Thanks very much for your time and coming on board today to help our members and clarify the extremely complex issues which are happening with the EU ETS. Thanks again.
It's been my pleasure. Thank you very much, everyone.
Thank you. Thank you, everyone. Thanks for joining in.